This is The Law Show on CL 650. Now back to the show.
Welcome back. The subject for discussion on this episode of The Law Show is family law. Our guests are Mark Perry and Anna Perry from Westside Family Law, which is in Vancouver, 1367 West Broadway, up there on the 4th floor, and online at westsidefamilylaw.ca. You've talked a couple of times about how important it is for people of at all stages of relationships, including those who are thinking about getting married, to talk to a lawyer, just to get a sense of the legalities involved and maybe that big game plan. Being in love and everything's pretty heady stuff, Mark, and you kind of lose perspective a lot. And so sometimes a conversation with a lawyer, however, as my daughter says, unromantic it may be, it's also terribly practical. Now, a lot of law firms offer free half-hour sessions and all that kind of stuff. What's the Westside Family Law approach to all of this?
Well, you know what? We used to offer free half-hour consultations, but we found from our experience that offering a reduced fee consultation made more sense.
Okay.
And there were some reasons for that, and I want to tell you about that. One was we take a consultation very seriously. We're bringing to a consultation lots of information. Sometimes when we encourage people to maybe email us in advance with some questions.
Sure.
And so we're looking at those questions. And those consultations we were finding were way more than half an hour.
Of course, yeah.
In family law in particular, there's an awful lot of trust building. There's an awful lot of just opening discussion about what's going on before you start to get into what really needs to be discussed. So as I say, we have found over time that offering consultations on a reduced fee basis made more sense.
Right. So that allows you the meter isn't running, Anna, so to speak. So everybody gets to relax and just talk it through. And I guess there are a lot of pretty private doors that need to be opened in these conversations. You deal with people discussing pretty intimate details of their personal lives. That's why they're in a family lawyer's office in the first place. So you can't get that all done in 30 minutes or less, can you?
Definitely not. I don't think I've ever done a consultation in 30 minutes unless it was someone that wasn't particularly serious about their matter. And by that I mean they were lawyer shopping. They'd already done a number of free consultations. Because the difficulty with free consultations is there are litigants who will run a majority of their initial litigation through multiple free consultations, which is very confusing for them at the end of the day and doesn't work well. But for us, our consultations is a good, solid hour.
Mm-hmm. I can well imagine, and in many cases, well beyond an hour, unexpectedly so,
Yes.
right? And you just can't turn off the tap. I mean,
No.
you start talking to someone, and they just start to open up. You can't go, oh, that's it, see ya.
Right.
You've
And
got to give them
I want
time.
you to understand too. We also have Kleenex in every
Well,
one of our rooms.
And I can well imagine that's a resource
and,
that
and,
gets.
and sometimes for us as lawyers as well.
Well, I wouldn't be surprised by that. The other, I wanted to also, because you talked a little bit and quite eloquently, thank you, Anna, about mediation. There's another step in the legal process in family law short of going to court, and between mediation and the courts is something called collaborative law. What's that all about?
Well, I guess I'll jump in. My collaborative training was a very intense one-week program, and it was attended by senior lawyers and also by judges. I wouldn't describe it as a new approach. As a matter of fact, it has its genesis in approximately 25 years ago in California. And it's been touted as the way to the new wave in family law. And interestingly, the lawyers have to commit to being collaborative, and we're talking big C collaborative because there's a collaborative law agreement that gets signed for the file.
Okay.
So you have a contract, and the reason for that is the underpinning of that process is complete and absolute honesty every fact is shared. All information is shared. You're not holding your cards close to your chest. You're not waiting in the weeds to surprise somebody with something at the courthouse door. No.
Right.
All our cards are on the table, and everybody is willing to talk it through. So this generates a very high degree of trust because nothing leaves that room.
Okay, because of the nature of the agreement that was signed in the first place.
Correct. And so the lawyers who represent the clients in the collaborative process are committed not to go to court, and the reason for that is we are the recipients of information that we may not, well, I can guarantee, would not receive in a litigation process because we have direct contact with the other party.
I see. Okay. Oh, so they can say things about and to each other that they could not in court.
Correct. And we have, as I say, generally speaking, a lawyer in a litigation setting does not speak to the other client. Everything is directed through the other lawyer. So in a collaborative setting, I can ask Joe questions, notwithstanding the fact his lawyer is sitting right beside him.
Right. Okay. So I guess, Mark, what I'm after here is how do you persuade clients, and we talked a little bit about some of the emotional highs and the tissue boxes in the office. Some of these people who come in are really, really on some kind of almost ethereal high. They're so angry and so worked up and so traumatized. How do you convince someone who just wants revenge and to go to war and all of those, aggressive activities to settle down and do the right thing for all parties, particularly themselves? Because I'm sure it must be a challenge to talk some people into that.
It is a challenge. It's often a challenge, but it's a challenge that, we go back to what you asked about earlier. Why did I become a family law lawyer? It's because of that challenge.
Okay.
It's because I think, our lawyers are generally calm people, reasonable people, thoughtful people. And so, the client who comes in, who presents in that sort of way, I want to outline to them the different options.
Right.
The pros and cons of different options. And certainly if I'm talking about a litigation option, about going to a trial, I will be telling the client how much that's going to cost them.
Right.
And that often has a very calming effect.
I would imagine.
Very calming effect.
Sure.
But we also spoke earlier about children and their interests being protected and their rights being looked after. And that's also part of that conversation, too.
Okay.
So Anna just spoke about collaborative family law and mediation and the ability to bring in experts to ensure children are protected and looked after.
Right.
That's less available, and often those interests are lost in a litigation process.
Right. Okay.
So, with persons with children, I might outline to the person, if we choose this option of proceeding to trial, this is what might be lost.
Right.
Keeping the focus on the children.
Our guests from Westside Family Law partners Mark Perry and Anna Perry. This is The Law Show here on CIL 650. Nice to have you with us. There's still more to come. Stay with us. After this, we're back.
There's more of the show still ahead. This is The Law Show on CIL 650.